Good morning. This is Mike Krawchuk. I'm a lawyer with WMCZ Lawyers in Saskatoon, and I practice in the area of employment law. So I was invited today to speak on the topic of what options employers may have in light of the COVID-19 crisis. Much of my practice does deal with employers, but I do represent employees too, so I have an understanding of both sides of the employment relationship. And with the COVID-19 crisis, a lot of businesses are struggling or will struggle, and this leads to the problem of income being reduced, and then the corresponding issue of what can be done with employees if there isn't the work to sustain them and the income to pay them. And if I may suggest that if people do have questions as my presentation is going on, if maybe they could be left to the end, so I can address them at the end, that might be the best way to sort of maintain a bit of a flow. And I should also mention at the outset that my focus is on non-unionized employees. The union context, there's similar considerations, but it is different. And also on Saskatchewan employees, those that are governed by the Saskatchewan employment laws. There is another regime under the Canada Labour Code that applies to federal employees, but most of the employees in the province are provincially regulated. So my presentation is going to focus on those employees. So as I like to start off with, there are a number of options for an employer who's faced with the business slowdown in how to approach their employee relationships. And the first one I'd like to talk about is if I could describe it as a bit more voluntary, a bit more informal, in that there's no real legislative scheme. And this is an agreement between the employer and the employee to temporarily modify their existing employment relationship. And this can be something as, well, it's just as common now, where people are working from home. This can be not only as a way to reduce the spread of COVID, but it also might be a way to reduce costs, which can extend the time that employees can remain employed. There are other options which are a bit more drastic, such as maybe employees agreeing to work share, which then may lead to employees having agreeing to reduced hours, with the consequent effect of reduced pay. Now, legally, this option is a bit of a challenge, in that law there are a number of statutory and also common law protections for employees and their employment agreements. One is that the Saskatchewan Employment Act does not allow any agreement that has the effect of depriving an employee of a right or benefit that the Act applies. The Saskatchewan Employment Act provides statutory minimums statutory minimum rights and benefits to employees in the province. But there also is layered on top of that the common law, which often enhances employee rights and protections. And one of these concepts is called constructive dismissal. And with that, what it does is it protects an employee from any unilateral changes to their employment relationship that are significant and to the negative. And even where an employee agrees to the change, it still might not be enforceable unless there is some sort of new value or additional value given to an employee. So So in the, I guess, as the law currently is, employees, let's say, agreeing to work sharing or reduced hours, could be seen as a constructive dismissal at the common law. So going forward with that sort of an option does have its risks for the employer. But in my view, and this is more practically speaking, for one, I think many employees may not want to balk at such arrangements under the circumstances, because with jobs being tight and with work slowing down, people may very well just want to maintain what employment they can, and also because of the unique circumstances. I think it's unlikely that after the fact many employees are going to want to take legal action against their employers for let's say reducing hours or reducing work during this period, because I think there's a sort of a general understanding that for employers this isn't really a voluntary situation either, and I think many people will be pleased to be able to maintain their employment and maintain an income. And I think especially if matters do go back, let's say, to normal in several months, and employers take back their employees, I think there'd still be a great deal of, let's say, goodwill between the two sides. And I think I think if an employer does want to proceed with this sort of an arrangement with their employees, and their employees do agree to it, I think after the fact of anyone coming back and saying, well, gee, you reduced my hours and reduced my pay during this period, I think I should get compensation for that. I think that's it's probably a low risk, and also with the way with the uncertainties of the situation and how the law is sort of reacting to it, I guess it's really unknown how a judge might treat the situation if it were to come before the court. Traditionally speaking, in situations of a constructive dismissal, an employee being able to stay employed has never been seen as enough of value to make such a let's say reduced time or reduced pay situation enforceable. But maybe under this current situation, it might be seen or taken by the court as being sufficient value. So there is, I guess, in my view, although there are some weaknesses or some risks for an employer approaching employees or making arrangements with employees for reduced hours and work sharing, I think it may be at the end of the day a practical option that all sides might be able to live with and stand by during this period and after. Now, there is an official program, sort of like the one I'm just mentioning. This was a federal work sharing program, and it is an agreement between the employer, the employees, and with the approval of Service Canada to allow employees to work or to share work over a defined period. Usually what it involves is an equal sharing of work, and sort of an equal reduction in pay, and one of the benefits of this program, if an employer is approved for it, is that the employees may get employment insurance top-up. So the employees shouldn't be too much affected in their pay by having to agree to such a program. And there have been a number of changes to the program as a result of the COVID crisis to make it a bit more accessible. And I guess pre-COVID, the length of the work sharing agreement could only, or the maximum was 26 weeks with a minor extension if approved. Now the federal government has allowed the an agreement to be extended to up to 76 weeks due to the COVID situation. Another change in the program has been the turnaround time for applications. Previously, an employer needed to, or employer employees needed to submit their proposal 30 days before they wanted to implement it. Now, with the situation developing more rapidly with COVID, the federal government has reduced that window to 10 days. In addition, and I won't get into, let's say, technical details of this, but they've also broadened the employees and employers that may be eligible to apply to this program. So this federal work sharing program, it's sort of like the temporary voluntary agreements that I had just discussed. But I think two key differences are, well, it's officially sanctioned. The federal government, Service Canada, needs to approve the proposed agreement, so that sort of avoids the problem of constructive dismissal. And the employees also have the ability for an EI top-up. A limiting factor, though, is that it needs approval of the federal government, but it still is an option that may be available. Probably more likely for employers that are able to foresee when a downturn is going to start hitting them and make plans in advance. That isn't always the situation under this current crisis. I've run into myself in my practice some employers who are able to plan ahead and are trying to take advantage of programs such as this, or others where, let's say, the government has ordered a closure, the ability to react is much less, and a program like this just is not actually feasible because, well, there's not the timeline and there's not really the ability to carry on going forward. So for those employers who maybe can forecast a downturn and hope to be able to carry on business through it, this may be an option that is possible. Now, turning to provincial laws, one option I have considered is the possibility of employers requiring their employees to take a mandatory vacation. The Saskatchewan Employment Act does allow an employer to require their employees to take a vacation as long as the period is for 1 week or more when their business is shut down. So the business will be shut down and the employees may then take their vacations during that period. One thing for employer to bear in mind, though, is that the employees must be given notice of the forced vacation, so to speak, and the shutdown, and it has to be at least 4 weeks notice. And the other, or another factor to bear in mind for employers that might be considering this option, is the shutdown also is, or would have to only be of a short duration, depending on how many employees the employer has. If there are varying vacation lengths, it might only be a possible 1 week or 2 week window for closure, because that will use up all the employees' vacation time. So really what this sort of contemplates is a very short closure, which under the current circumstances may not be practical for many employers, especially since we really don't know how long this pandemic is going to last and how long businesses may be either slow down or out of work entirely. So, a 2 or 3 week closing period just may not be enough. And the other factor too is that this is a vacation for the employees, so they will need to be paid during it. So if as an employer, it isn't just a lack of work, but also a inability to pay, then a mandatory vacation is not really going to be a solution, because the employer is still going to have to pay their employees during this period. And then once the vacation period's over, resume business again. So really, the mandatory vacation option is really a limited option that's possible maybe only for certain employers who maybe are only contemplating or required a short slowdown without a real hit to their finances. Now, a very broad option, which has become increasingly common in.
No, it's okay. I understand.
Sorry, Mike.
I understand.
Thank you.
Just a
Yes.
reminder for everyone, if you could all mute your lines, please, that would be great. Thank you.
I have to do it through the
One option that's become increasingly common recently is a layoff. And a layoff is, it's a legal concept, is a termination of an employment relationship, but with the intent to rehire the employee or employees at a future point. This is the idea of a layoff is not a new concept. It's quite common in the past, especially in situations in certain industries of short-term economic slowdowns. And traditionally, what has been required in the case of a layoff is that the employees get notice of the layoff or pay in lieu of that notice. And the amount of notice depends on the employee and their length of service. This is detailed in the Saskatchewan Employment Act. Notice periods of 1 week up to 8 weeks, depending on the employee's seniority. Now, with the COVID pandemic hitting so suddenly and the government ordering certain businesses to close, this requirement for notice or pay in lieu of notice became somewhat problematic for some businesses, especially, let's say, those that were ordered to close by the provincial government. There just wasn't the time to provide working notice. It just wasn't actually possible to provide, let's say, 6 weeks working notice to employees that there's going to be a layoff. Coupled with that, there in many cases was an inability to provide the alternative of pay in lieu of notice, because providing pay of, let's say, 4, 6, 8 weeks to 5, 10, 20 employees had the potential to bankrupt some employers. And not only did that would have a negative effect on the employers, but the trickle-down effect, of course, to the employees would be that either they may not receive their pay in lieu notice, or the employer might not be around at the end of the pandemic to rehire them. So to deal with this emergency, the government did release regulations to the Employment Standards Act, and it effectively has removed the requirement for notice or pay in lieu of notice for layoffs in a situation where a public emergency has been declared, which there has been in Saskatchewan as of March 18th. And the proposed layoff is for 12 weeks or less in a 16-week period. So what this now allows is for an employer to give a immediate layoff to an employee without any pay in lieu of notice. And I think with these amendments, what the government was seeking to achieve was to not have employers bankrupted, to have them in a position where they they can revive their businesses after the pandemic is over, and that those employees who have been laid off may then be re-employed at that point. And in the meantime, the state would then handle or take over providing for the employees' income until they can return to work. So, sort of turning to that topic, there are a number of government measures to provide income for employees who found themselves out of work. The traditional means was employment insurance, and this was meant to provide temporary income for a employee who is temporarily out of work. And it required for eligibility a interruption of earnings, which would be the employee being separated from their employment, having performed no work for their employer for at least 7 days, and having no earnings payable during that period from work that they had performed. And as long as the employee met those requirements, they may then be eligible to receive 55% of their income to a maximum of $573 per week. So some means or measures to bridge the gap from loss of job to reemployment. In some cases, employers can top up the employment insurance that their employees had or will be receiving. The federal government does have a supplemental unemployment benefit program, and an employer may apply for this program. And what it may do, if the program is approved, is the employer can top up the employee's income so that they make 95% of their pre-layoff income. And this application is made to Service Canada, sort of in the same vein as the work sharing program, and it also has to be made prior to implementation. So it's not. It's again. This is a supplemental unemployment benefit is something that is more possible if the employer is able to forecast when layoffs are going to be necessary, as opposed to the situation maybe where layoffs are more suddenly imposed, let's say by government closure. Now, I referred to employment insurance as being the traditional method of income replacement in Canada, but in response to the COVID crisis, the federal government has created a new program called the Canada Emergency Response Benefit, and it is been available since April 6th, and it provides for a $500 payment every week for up to 16 weeks, and it is run not just by Service Canada but also by the CRA as well. And now what happens is, as of April 6th, people now, instead of applying for employment insurance, they apply for the emergency response benefit. And those who had applied for employment insurance prior to April 6th, their applications are now being assessed for eligibility for the emergency response benefit. So with respect to the COVID crisis, the emergency response benefit has effectively taken over supplementing people's income in this situation. Now, it does aim to provide a similar remedy as employment benefit. The emergency response benefit, though, being targeted to those specifically who are not working because of COVID. But there are some differences. One is that it does provide a flat amount payable. Employment insurance has the percentage amount based on the employee's income pre-layoff, whereas the emergency benefit is a flat $500 every week. And the other thing, which is I think helpful in this crisis situation, is that the employee can apply right after they're done working, or they've been forced to stop working, and they may still apply even though they have earnings payable from their previous employment. So what I interpret that to mean is, if the employee is laid off because of COVID, but they still have a paycheck coming, they can still apply for the emergency benefit. Whereas under the EI regime, the employee would still have to wait those 7 days. So it does provide a bit quicker of a turnaround for the employees to receive their benefits. I guess what is still a bit of an unknown, though, is how the emergency benefit may interplay with the supplemental unemployment benefits that I just mentioned that are available with EI. Currently, the legislation doesn't actually provide for a employer top-up for the emergency response benefit. Now, with existing programs, they are still going ahead. The employer is still allowed to top up under their EI programs, but it gets a bit of an unknown with this emergency response benefit. My speculation, and maybe it's a reasonable speculation, is that the government will allow amendments to the legislation to allow employers to top up emergency response benefits. I think for two reasons. One is it was allowed in the past with EI, so I wouldn't see a reason why it wouldn't be allowed for the emergency benefit as well. And secondly, I think there's a desire on the part of the federal government where, as far as possible, they would like employers to still be able to contribute some income for their employees, and this might be a way to facilitate that if employers can still do the top up. So it hasn't happened yet, but I anticipate that in days or weeks to come, that employers will be able to top up employee emergency benefits just as they have for employment insurance benefits in the past. Now, if I just maybe turn back to new provincial laws, I mentioned before the change in layoffs, where the requirement for notice or pay in lieu of notice has been exempted. Another new development in the employment law realm was the creation of public emergency health leave. And this is available for employees in cases where there is a public health emergency declared by the chief medical health officer, and the employees have been directed to go home to isolate and to stop the spread of the disease. They can be directed by their employer, the doctor, or the government, and then they will be effectively on unpaid leave. This leave is a bit different than a layoff. One difference is that the employment contract is not actually terminated. The employee is still technically an employee of the employer. So, this leave then sort of automatically is dispensed with the requirement for notice or pay in lieu of notice. The leave can be immediately directed or taken voluntarily. That's another difference as well, is although provision is made for an employer or medical practitioner to direct employees to go home to isolate, it is also possible for an employee to request it for certain reasons. Another difference, I think, between a leave and a layoff is, whereas as a layoff has the intent to hire the employee back when the pandemic is over, with leave, the employee has the right to return because they are still an employee. They are still under employment contract. So when the pandemic's over, they have a right to return. And another benefit is, or another difference is that benefits do remain in place because they are still are still employees. But there are, I think there are some similarities with the layoff, in particular that an employee may be directed to take a leave, which is effectively not that much different than a layoff when you are effectively told that there's no more work for you for the next little while. And another I think, major similarity is that an employee would qualify for either EI or the emergency fund benefit if they're on unpaid emergency health leave. So in addition to the government taking measures to assist employees with financial relief, the federal government has also put forward subsidy programs for employers to provide them with financial relief. And there's been two that have been put forward. Both involve amendments to the Income Tax Act. The first one that was rolled out was the temporary wage subsidy, which is available for small businesses, and it provides for a 10% tax credit for small businesses for remittances for employees. The other one, which is a bit broader, is the Canada Emergency Wage Subsidy, and it actually provides a subsidy of 75% of employee wages, and it's not only is it a larger subsidy, but also it is available to a broader group of employers. The temporary wage subsidy was really aimed at small businesses, and that's where eligibility was focused on, whereas the Canada Emergency Wage Subsidy is available to not all employers. For example, public employers like municipalities are not eligible, but it is available for most other employers. And for the emergency wage subsidy, there also is a requirement to demonstrate decreases in gross revenues. Initially, it was a 30% across the board, but because of the way the COVID crisis has hit, say a little bit of a slower start at the outset, employers are let's say only required to show a 15% decline in revenues in March. Now, both of these subsidies are aimed for a 3-month period, so starting in the middle of March and lasting until the end of June. I think theoretically, an employer could apply for both subsidies. I mean, if you're a small business, I think you could really be eligible for both. But what I understand is if you get approval for the temporary wage subsidy, it would actually decrease the amount one might receive under the Canada Emergency Wage Subsidy. So I think the way to go forward is employers will choose which one makes the most sense under their circumstances. So, as a employment law practitioner, professionally, it's been a rather an interesting time. There have been a lot of changes over a short period, and some changes that I don't know if they're unprecedented, but I guess in my experience they've been unprecedented. I think the idea that for layoffs, the notice requirement or pay in lieu of notice requirement being removed could be unprecedented. I don't know if that's ever happened in the length of time that such concepts have been available at law. So with these new changes, I think there are uncertainties caused. I mean, these changes obviously are meant to address a current crisis. But how things will ultimately play out are a bit unknown. And one uncertainty I've sort of thought about is how the length of the pandemic might impact these measures that the provincial and federal government are taking. And by that I mean these measures that are taken are generally meant to be short-term measures. For example, the layoff exception that has been created is meant to be 12 weeks. The emergency response benefit is meant to provide income supplement for up to 16 weeks. The temporary wage subsidy and the emergency wage subsidy are meant to last for 3 months. So I think your question is, what happens if the pandemic lasts longer than the middle of June? The way the law is currently set up is those benefits or those exemptions will then sort of fall off the table, and we'll be back to where we were in the beginning of March. So that then revives all those concerns that were at that time. I guess my hunch is that if the pandemic still is in full force, so to speak, many of these legislative initiatives will be extended. But it gets a bit more complicated if let's say the pandemic is slowing down. What happens then? How are new measures, or how are these existing new measures modified, or are new measures crafted? I guess we don't know, and we won't really know until we get closer to that time. Another challenge I see on the horizon is when it is time to return to work, be it the pandemic is over or it's slowly becoming over, because these emergency measures, such as the layoff exception or public emergency health leave or the emergency relief benefit, seem to be predicated on the idea that once the pandemic's over, employees will return to work. But I mean, the reality might be, what if employers can't bring back all of their employees at that time? It's quite possible that, let's say, for example, if an employer had 10 employees pre-pandemic, when it's over and they're able to let's say open doors again, they may not be able to hire back all 10 employees on day one, or at all. So what happens then? Is it then that, let's say for a layoff, that then the employer is required to pay severance pay? I don't know. I don't know the answer to that. Another question is in terms, if there is severance pay, what amount should it be? I mentioned before the interplay between the minimum of the Saskatchewan Employment Act and the common law, which might be more generous in its protections for employees. One of those is severance. An employee who, let's say, under the legislation might be entitled to 8-week severance, could be entitled to 8 months or 10 months at common law. So if an employer starts their business up again at the end of the pandemic and can't take back an employee, are they then faced with paying a large severance amount at that point? The way the law currently is set up, that certainly seems to be a real possibility. Will there be any intervention, judicial or legislative? Perhaps. I guess we'll see. A sort of related problem is, what if employers can only slowly bring back their employees? Under those circumstances, if there are 10 employees and can't bring back all of them at once, who comes back first? In the meantime, for the ones who are still waiting, how will they get paid? Will the emergency relief fund provide income? Will it be EI or what? then when is an employee deemed to be terminated? If you know, if an employer has those 10 employees and brings back some, well, how long does that last employee have to wait before they determine that no, actually you're never bringing me back, and I've actually been terminated? So these are you know, unknown or questions with unknown answers at this point, which the law will probably have to grapple with at that time. Whether it'll be legislative or judicial, I guess time will tell. But these are things that I foresee on the horizon once the pandemic is over. And I think, like the outset, where new remedies were crafted to deal with the onset of the crisis, may very well be that new measures are brought in to deal with the fallout after it's over. That is my presentation for this morning. So thank you for listening. I guess if anyone has any questions, I'm happy to take a crack at trying to answer them. So if you have any questions, just send them on my chat. And if not, I'm good with that too.
Awesome. If anybody has any questions, feel free to type it in the chat or unmute yourself.
Hi, Mike. It's Wade here. I was going to type it out, but I'll just ask you here. When you were talking about EI eligibility, one concern I have as an employee is I get paid commission on a 3-month rotation, basically. So what I earned this month, I would get paid for the next 3 months, and I've been temporarily laid off. Is that going to affect my EI eligibility because I will still have that income coming in, or do you know?
I think, you know what, I think strictly speaking, it probably would. But I think that with the emergency benefit fund, I don't think you would have that same problem there in making application.
Okay.
Now, I'm not sure the details of how any income received affects the emergency fund, but that might be an issue as well. I know with EI, any income you receive during your unemployment is set off. It may be the case with the emergency fund. I'm not sure about that though. But I think you still may be able to apply as long as you've stopped working because of the COVID crisis.
Okay, thanks for that.
Welcome.
All right, I'll assume that there's no other questions. I think the presentation was very thorough, and that's probably why. So thank you, Michael, for taking this time out with us and offering all your expertise on all these topics. I think there's so many things that perhaps we had questions about or we didn't even really think of, and we covered that today. So thank you for your direction. This has been super, super valuable. Your support, the support of WMCZ lawyers, of everyone here today, the program as a whole is very, very much appreciated. Thank you for that. Should anyone wish to review your presentation again or get in touch, we'll have your presentation available on our website, as long as you're okay, for participants, along with your contact information in case there's any other questions. Just real quick for everyone, thank you for joining us. Our next webinar will be 10 a.m. on Thursday with Jill Souter of Jill Souter Marketing and Communications. She'll be speaking on marketing, adapting our strategy to meet clients' needs. We look forward to having you join us on Thursday, and please feel free to invite others as always. Further details can be found shortly on the Rajmatic website under events or in the calendar. You'll also be able to share details from our Facebook page, Instagram, and Twitter. So again, thank you so much, Michael, and thanks everyone. Have a great rest of the day.
Thank you.